Hi, I'm Perry Atkinson, General Manager here at theDove. Hey, check out our other videos and check out our website at thedove.us. Welcome back. Hey, I'm delighted to have back with us today Dr. Lawrence Gelman. We've had him on several times. He's authored a book that is really fascinating. It's called Fall from Grace. You may want to check it out at the bookstores. Well, actually, not at the bookstores. We'll tell you how to get a copy of it. It is a huge book and well documented, and he has done his homework. Dr. Gelman is a Texas-based physician, hospital administrator. He's a conservative activist. You see him on some of the big shows, but he's made it to the big time because he's on theDove. And he actually hosts his own radio show now and then, so he's a pretty busy guy. But today I wanted to have him back because our last couple of conversations, he made reference to some of the cases that the Supreme Court made decisions in, some of which perhaps have weakened the Constitution, and we want to talk about that. Dr. Gelman, nice to see you again, my friend.
Nice being back.
Yeah, good to see you. Well, I'm not sure where we start this because you made the comment the last time we were together. You think that some of the earlier Supreme Court decisions have weakened our Constitution. Give us an example of one of those.
Well, you have the you can look at the one they just had, Sebelius versus Small Business Association of America, where they legalized the Affordable Care Act. I think there are many Supreme Court decisions which have essentially undermined the Constitution. So it goes all the way back to the first major Supreme Court decision, in which the Supreme Court took it upon itself to be the interpreter of the Constitution, and that was the Marbury versus Madison decision. Before we go into that, I think we have to look at underlying motivation. Remember that the Supreme Court is part of the central government, and the central government in all throughout history has done only one thing only, and that is to increase its own power. Mm-hmm. And so that's due to the political mind. It's the psychology of human beings. People go into politics, go into government, have a certain psychology. And there's one thing that ties them all together, and that psychology is they want to control the lives of other people. The Constitution was written specifically to prevent the government from controlling the lives of other people. Therefore, you had conflict between the psychology of the politician and bureaucrat and the Constitution. Remember, the Constitution is written by human beings, and what human beings can do can be undone. If you have the psychology of remember, the Constitution places constraints upon the federal government. Politicians do not want constraints. They want to control your life, and the more lives they can control, the better. And so it required adherence to the Constitution in order for the Constitution to function. But the political mind has superseded what the Constitution says. They've undermined the Constitution, and through our corrupt system of public education and our state-controlled media, we have come to believe something which is something other completely than what our founding fathers had intended. Now the government does run our lives. Your program, what I do every day, this office, the hospital, everything, driving your car, everything now is under the control of the United States government. There is nothing that an individual in the United States can do that is not somehow controlled by the United States government. That's not the way it was supposed to be. And the Supreme Court has become the sword that has severed the Constitution from the American people. And the way it does that is in every one of its decisions, and it really doesn't matter if the decision favors so-called conservatives or liberals. In other words, the Heller decision, which the Supreme Court said that the people of Washington, D.C. have the right to bear arms, and conservatives consider that a victory. Or this last decision, this Hobby Lobby decision, which went in the favor of so-called conservatives, is considered a victory for conservatives, is really a loss. And that is really the ironic thing. It's a loss because once you accept the Supreme Court as the final interpreter of the Constitution and determining what's constitutional, you've already lost because the Supreme Court has no such authority. So therefore, once you accept the Supreme Court in decisions, you accept their decisions that you like, then you're constrained to accept the decisions that you don't like. And even the ones where it's in our supposing our favor, whether the Heller decision or any other decision which appears to be in our favor, it really isn't, because every decision, even this last one with the Hobby Lobby, ultimately puts the final power in the hands of the government. And when you do that, you have lost your constitutional basis of the nation.
Wow, boy, there's so much in there. I've never heard anybody tie in the psychology that you just did. In addition to that, do you think that the Supreme Court is taking cases they should never take? In other words, they're making decisions on issues that they shouldn't even be bothered with.
Absolutely. First of all, the Supreme Court is the powers of the Supreme Court is in Article 3. Article 3 is the shortest article as regards the central government functioning, legislative, executive, judicial branch. It is the one with the least power. It meant to be the one with the least power. And now, the Supreme Court has no say in legislation. The Supreme Court has no say in the amendment process by the Constitution. Therefore, the idea that they can interpret the Constitution is completely bogus. The Supreme Court only is to function in issues between states and between the United States as a nation and foreign entities. And that is the only authority it has. The only other authority it has is in cases of crimes of national effect. For example, treason, which is a national crime. Counterfeiting is a national crime. Piracy is on the open seas, so that's not tied to any particular state. Supreme Court has no power whatsoever within a state. So if a state wants to pass a legislation, and the legislation is only internal to the state, and the legislation does not affect the rights as delineated in the Bill of Rights, then the central government has no authority whatsoever under any circumstances, including the federal government, including the Supreme Court. So if a state says that they're going to prevent the abortion of the undelivered infant by law, the federal courts have no authority whatsoever to have any effect on that law whatsoever, as long as the law is confined to the state within the borders of the state. In fact, 99% of the cases the Supreme Court deals with, which are really arcane for the most part, and I've sat in on a number of Supreme Court sessions, is well outside the authority of the federal government and the Supreme Court. Essentially, we no longer, a nation can consist of more than one country and more than one group. Our nation is under a single ideology, and we are not a country. We are a nation. We are a nation of a confederation of independent states that have voluntarily come together under the Constitution and have agreed voluntarily to accept the tenets of the Constitution. That is our nation. The federal government is supposed to be involved in only national issues, not intrastate issues. But what do we have now? We don't even have states. We have provinces under a central government, and we are under the direct control of the central government. The federal income tax is completely unconstitutional. Almost every time you see a case being decided by a federal court on a state law, that is unconstitutional. But then again, they have the power. So they do it because they have the power, but having the power doesn't make it right.
When did the Supreme Court declare themselves the final arbiter of the Constitution? In other words, if they inserted themselves to be the final arbiter of the Constitution, then the states maybe didn't even know they surrendered it.
Well, they've been surrendering it slowly. Initially, the states, the Marbury versus Madison decision was the decision where the Supreme Court, Judge Marshall, took it upon himself to say the Supreme Court is the final interpreter of the Constitution. You have to understand that Marshall was a Federalist, like Alexander Hamilton was a Federalist. They were very interested in a very strong central government and very weak states. And to show you how things have changed, the back in around 1800 or so, 1790, there was a case called the Chisholm versus Georgia case, in which a citizen from one state, I think it was one of the Carolinas, sued the government of Georgia. It's really not important why, and the Supreme Court came into that case at the behest of the plaintiff, and stated that they have the authority, according to the Constitution, to be involved in a case, to make a decision in a case between a citizen of one state and the government of another state. And the states were so incensed that they passed the First Amendment beyond the Constitution, which is the 11th Amendment, which specifically prohibited the Supreme Court from doing that. And I'm going to read it to you real quick. The judicial power of the United States shall not be construed to extend to any suit in law or equity commenced or prosecuted against one of the United States by citizens of another state or by citizens or subject of any foreign state. The states were so incensed by the Supreme Court getting involved in an affair internal to the state that all the states passed the 11th Amendment. And there were only two amendments that were done in the lifetimes of our founding fathers. That was one of them. And that amendment prohibited the Supreme Court from being involved in a case from a citizen of one state suing the citizen of another case, the citizen of one state suing the government of another state. But things have definitely changed now. Now, in that decision, it was a completely contrived decision by Marshall. When Marshall was the Secretary of State under Washington, when Washington was leaving, when John Adams was leaving office, when he lost the election to Thomas Jefferson, the Federalists, because remember, Thomas Jefferson was a Democrat Republican, Adams was a Federalist, and Marshall was a Federalist. So when Marshall was the Secretary of State for Adams, he was involved in trying to get as many Federalist judges on the bench before the new administration, to try to pack the court, so to speak. Nothing new. And so, but what happened was that then when he was made Supreme Court Justice, and Marbury was denied his judgeship, and so he filed a case saying that the government was responsible, was obligated to grant his judgeship. And the case went to the Supreme Court because James Madison said, "The heck with you, we're not doing that. We don't have to do that. We don't agree with you being a judge or these other guys. You guys, you're a Federalist, and we don't agree with you guys." So they went to the Supreme Court. Interestingly enough, now remember that Marshall was trying to pack the court with Federalists when he was in the Federalist administration under John Adams, Supreme Court Justice. He's still trying to achieve the same thing. So what he said was that the authority that was given by the Judiciary Act of 1789, that the authority given to the courts in order to do a writ of mandamus, which requires an entity to obey a court's order, was outside of constitutional stipulations and therefore unconstitutional, because the Congress passed that law of the Judiciary Act in 1789, which was unconstitutional, and the Supreme Court said it was unconstitutional. Marshall said, well, clearly the Congress made a law that was unconstitutional. The unconstitutional nature of that law. Therefore, clearly, the Supreme Court must be in charge of interpreting the Constitution, because the Congress seems to be incapable of doing so, and of course the president as well. And so Marshall took it upon himself to say, we're the only ones qualified to interpret the Constitution. But it's all bogus. It's all bogus. It's not at all what was said in the Judiciary Act. There were 30 sections in the Judiciary Act. He picked out one little bit of it that he did not agree with, though there's nothing wrong with it, but only as a ploy in order to justify the Supreme Court taking over control over the interpretation of the Constitution. Wow. And so you have a number of Supreme Court decisions after that, and all of those, and every major Supreme Court decision regardless whether conservatives agree or disagree with the opinion. And in fact, I only found one or two of all the ones I studied, more than 40 cases, in which there was actually the Supreme Court adhered to constitutional principles. And all the other decisions, even the ones that appear to be in our favor, conservative favor, are not. Because every time we say the Supreme Court has the authority to make such a decision, we weaken the constitutional basis of the country, of the nation.
Fascinating. All right, let me take a quick break. We'll be right back. You may want to check out his book or get a pencil. We'll tell you how you can get a copy of a book called Fall from Grace. This is just one of the things that he talks about in it, and extensively, and has done his research, and we'll share all those details with you. It's extremely well researched. Dr. Lawrence Gelman, we'll be back with him in just a moment. Okay, we're back with Dr. Lawrence Gelman, and fascinating review of the Supreme Court and usurping its responsibilities and authority. And he's put all of this in a book called Fall from Grace. There's a picture of it on the screen. This book is huge. It weighs a ton. Dr. Gelman, how do they get a copy?
Oh, just lrgelman at AOL.com. Just that and $20.
All right, lrgelman at AOL.com. Connect with them there and get a copy of the book. Yeah. All right, so this is absolutely fascinating. Now, obviously, Congress relinquished its responsibility of being a guardian to the Constitution and gave it to, or let it be taken from them by the Supreme Court.
Right.
Why hasn't legal scholars jumped on this?
Because they're all in bed with the government. I mean, attorneys are part of the government. Let's go back to the political mind. The political mind is the control of other people's lives. What does a judge do? He wants to control the lives of other people. What does an attorney do? The same thing. Politicians and bureaucrats. They all have the same psychology. Now, maybe their motivations are for good or for evil. But the fact of the matter is, once in the psychology, I don't want to be told by anybody what I can or cannot do, whether their intentions are good or not, because that's not what the Constitution says. The Constitution says that we have the right, the Declaration of Independence says that we have the right to pursue our own individual idea of happiness, not the government's idea of happiness. But before I go on, I just want to make this I want to show you what Marshall does real quick in his decision. What he did was, he pretends to quote from the Constitution, and he says, in all cases affecting ambassadors, other public ministers and consuls, and those in which a state shall be party, the Supreme Court shall have original jurisdiction. In all other cases, the Supreme Court shall have appellate jurisdiction. Okay, this is what the Constitution does say. In all cases affecting ambassadors and other public ministers and consuls, and those in which a state shall be a party, the Supreme Court shall have original jurisdiction. In all other cases before mentioned, the Supreme Court shall have appellate jurisdiction. You see what Marshall did? He left out the words before mentioned because it makes it seem like what he wrote down in all other cases they shall have appellate jurisdiction. No. It's in all other cases before mentioned. The before mentioned are the specific cases that the Supreme Court is allowed to be involved with. He changed the wording, pretending to quote from the Constitution. He took out those two words, making it appear that the Supreme Court has unlimited appellate authority, and it doesn't. Now let's take a look at the Supreme Court. When the Supreme Court is in the Constitution, it does not say how many members of the Supreme Court there ought to be. The Judiciary Act of 1789 made 5 members of the Supreme Court. The Supreme Court has ranged between 5 and 10 members, and Franklin Roosevelt tried to increase it to 15 in his bid to control the court. Now think of it for a second. What the Constitution specifically says, talks about tiebreakers. That's why in the Senate there's a tiebreaker, who is the vice president, and everything is structured so that in legislation, if there's a tie, there's a way to break the tie in order to pass the legislation. But the Supreme Court, nothing is set up like that. In the Supreme Court, they don't have any tiebreakers. Also, the number, unlike in the legislature, which the numbers are fixed, the numbers of the Supreme Court members are not fixed. it is, and so it is impossible that our founding fathers would have allowed the interpretation of the Constitution to be decided in such a manner, because in such a manner you have these 5-4 decisions. That's impossible. Essentially, that gives the interpretive power of the Constitution to one person. Remember, the United States was founded in a rejection of the king as the sole authority of a state. You think the founding fathers, after having overthrown the aristocracy of Great Britain, would then set up a structure that will allow a single individual to decide what the Constitution says? The function of the Supreme Court is not to decide constitutionality. The legislative process is in control of the legislature and, to some degree, the president. The Supreme Court is out of it completely. The Supreme Court can only decide an issue based upon what the law says. For example, you have homicide, and there's some things which are legal homicide and some which are illegal homicide, and that's murder. Illegal homicide is murder. And the law says this is justifiable homicide, this is non-justifiable homicide. The Supreme Court cannot say, oh, that law is wrong, is not constitutional. No, no, no. The Supreme Court can't do that. All the Supreme Court can do is take the instance that occurred and decide whether within the law as it exists, whether it is inside or outside the law. The Supreme Court is not allowed to interpret the Constitution. It can only interpret a particular case based upon constitutional principles.
Wow. So, what do we do?
Well, I mean, you asked a question, but ultimately it's going to require force. There's nothing to be done. I mean, you know, George Washington, Thomas Jefferson, Benjamin Franklin could have gone and discussed and debated before the Parliament of England till they're blue in the face. Nothing would have happened. Ultimately, it's a question of force and authority. And why should we be surprised? What has the government done to us? Exactly the same thing. It's through force that they require us to do all these things, right? To pay a federal income tax, to pay a Social Security tax, to pay a Medicare tax, to be in a Medicare system. If you don't go along with the federal government, they use force against you. What happens to you if you don't pay your federal income tax? You go to prison or they confiscate your property. So let's not say that this is a voluntarily functioning country. We do what we do because we're forced to do it. And the only way the government is going to change if they're forced to change. How are you going to force them to change? I don't know. I can't say that on the air. But the fact of the matter is that you can forget about political parties. You can forget about Congress. You can forget about anyone coming along and doing what needs to be done. We are so far down the path of perdition that there's no return. The only thing that can be done is that this government needs to be dissolved. There's two options. You either dissolve the government somehow, that's not going to happen on their own at least, or a state secedes. The states belong to the Confederation voluntarily. Secession is perfectly constitutional. In fact, when the Constitution was ratified, only 9 of the 12 or 13 states at the time even ratified it. It was just a majority. So there were states that didn't even belong to the central government, and they joined later once the Bill of Rights was incorporated. So it's a voluntary association, Abraham Lincoln notwithstanding, who was a gigantic fascist, by the way, and who was congratulated by Karl Marx. There's a letter from Karl Marx written to Abraham Lincoln congratulating him on his victory, and also Adolf Hitler was an admirer of Abraham Lincoln, because Adolf Hitler did what Abraham Lincoln did, which was force the Bavarian countries to become part of the German nation. And he agreed. So that's what Abraham Lincoln did. He, through force, through murder, through killing of civilians and children, and through imperialist policies, and he destroyed the South, killed hundreds of thousands of people for one reason only: to create a powerful central government. So that's what we got. Okay. So the only thing that we can do now is, as each state that doesn't want to belong to the Union should secede from the Union. That is really the best answer, and I think the only answer. And the question I have for any able-bodied American is, what benefit do we derive from being part of being under control of the central government, where we have our sons and daughters in Iraq, in Afghanistan getting killed by our allies, where we were in Iraq and we overthrew a government, and now no Christian is safe in Iraq when they were perfectly safe under Saddam Hussein. And that's our fault. And all the things that we've been involved with, whether in the Middle East or any other parts of the world, where our sons and daughters are put at risk because of the harebrained schemes of our central government, whether that's Barack Obama or George Bush or Bill Clinton. It's bipartisan, okay? So what benefit do we derive from the federal government stealing all our money and then spending it in ways that we do not approve? I don't want my money being spent to give money to some single mother in New York City and deprive my children of the benefits of what I have earned because some congressman in New York thinks that an unemployed, uneducated person in New York having one baby after another, that my money should be spent to take care of those children. I want my money spent on my children. But the federal government is the one, every problem that we have, whether it's immigration, whether it's drug policy, whatever you want to say, every single problem that we have is created by government. Government is the great evil. Okay, that is government is as Mr. Payne said in his pamphlets. Government is the great evil, and all the best you can hope for is to create a lesser evil.
Wow. All right, I'm out of time. Let me just say to our viewers and listeners, L.R. Gelman at AOL.com. LR at AOL.com is one way to get a hold of him. The phone number is 956-566-9328. And you can order a copy of the book for about $20. Dr. Gelman, thank you. Fascinating, because I think that we know something's wrong when the Supreme Court somehow became the final answer of everything. And at that point, they're king, we're nothing. You know?
That's true.
Yeah. Thanks, my friend. Thanks for your passion. Keep up the good work.
Sure. Right. Okay, anytime.
All right, God bless. We'll see you next time on Focus Today.